Welcome and thank you for attending. All parties are in listen-only mode for the duration of the presentation. Questions may be asked the presenters via the questions pane in the webinar control panel. Today's presentation will be recorded. If you have any objection, you may disconnect at this time. I will now turn the presentation over to your presenter. You may begin.
Good afternoon, SHRM, Long Island. It's Friday, June 29th on an early holiday weekend. This is Henry Shapiro. I apologize for those who wanted Chris Valentino, but you get me, so second best in my opinion. So today we're going to talk about the recent week. So this is meant to be an update. Doesn't get much more updated than this. So today's topic, and you can see my wonderful artwork on the first slide, the red, white, and blue, getting ready for Independence Day. Fireworks in Washington. We're going to go over the Supreme Court. We had a big retirement the other day of one of the justices, Justice Kennedy. We had a big labor law case that I am sure many people on this call will say, I'm not a public sector employee or employer, and I am not a unionized employer. And that's all well and good, but I'm going to tell you why it's going to matter for you going forward. So the court is changing, times are changing, New York is still the same, but I think we got a lot to learn and we got a lot to cover in the next 18 or so minutes to send you off into your weekends and hopefully enjoy this 95-degree heat wave. So what's new in D.C.? The Supreme Court wrapped up its term this past Wednesday, so it is now off for the summer. They will reconvene in October, but for now, there's nothing going on at the Supreme Court. What you will hear a lot about are the upcoming nomination or appointment by President Trump and the confirmation hearings for the soon-to-be next Associate Justice of the United States Supreme Court. So this term, we saw a lot. I think we've seen a lot in this presidential administration, a lot at this government. We all, I'm sure, heard of the travel ban from President Trump on mostly Muslim countries. That was upheld as constitutional. There's been a couple of other cases that I'm sure you've seen that have been in the news regarding the baking of the cake in Colorado. And the other big news, and we're going to get to that labor law case, the other big news story, as we said, Justice Kennedy is 81 years old, so he's definitely on one of the more senior judges as far as his time of service on the bench. He's been on the bench for 30 years at the Supreme Court. He was an appointee of President Reagan, but historically, he has not been a hardline conservative on all issues. He has not always voted with his Republican counterparts, and I use Republican as a method of thinking and an ideology. There's obviously no real political parties on the bench. So just this past Wednesday, after this Janus case, which we're going to get into, this labor law case, after that decision was announced, we thereafter shortly heard from Justice Kennedy through the White House that he will be retiring this July 31st. Supreme Court will be closed for business, but that's when his retirement will go in. He will have served 30 years, being appointed in 1987. And this is going to give President Trump an opportunity to appoint another justice to the Supreme Court. We all know the first one he appointed is Judge Neil Gorsuch. That was last year. So as I'm sure many of you will remember, back in 2016, even 2015, during the election season, the Democrats, the Republicans, this was a big bone of contention. The next president, whether it was Hillary Clinton or now President Trump, was going to have a major influence over the Supreme Court, and we're seeing that play out. So this is not so much a surprise as it is something that we all kind of knew was going to be a foregone conclusion. I don't think Justice Kennedy was everybody's thought to be the one to retire. There's other possibly more likely candidates, but for now, these are the cards we're dealt. President Trump will still have a few more years. You could turn on the news, I'm sure, if you want to see the battle that is going to ensue between Democrats and Republicans in the Senate and in Congress generally over the Supreme Court nomination process. So the big thing about Justice Kennedy is he's always been known as a swing vote in major cases. He's on social issues, gay rights, gay marriage. He's often voted with the liberal side of the bench. That's Justices Ruth Bader Ginsburg, Sotomayor, Elena Kagan, and Stephen Breyer. So those four, then you got the four on the other side that are of the conservative mindset. They split. They were often going to go 4-4. And then Justice Kennedy was often the deciding vote one way or the other, depending on his line of thinking and depending on the issue. If President Trump now appoints a conservative, a strong conservative, similar to the Gorsuch, Justice Alito, Justice Thomas mentality, then the expectation is this is going to it will shift the court to the right. It's a shift that could stay like this for generations. I'm talking decades, where we will see it through their decisions and through case law and through the cases that are decided below them, knowing where they're going to end up, that this is going to be a conservative panel of decisions. It is going to be arguably more employer-friendly, less employee-friendly, based on the trend we're seeing. Right now, the Senate has a majority. The Republicans have a majority of the Senate, I should say. And based on the Constitution, they should not face very much in the way of opposition from Democrats right now on trying to put through President Trump's next nominee. That could change if the nominee is not confirmed prior to this year's midterm elections in November, depending on how those turn out. But there's a lot to pay attention to this summer, because I'm sure this will be the first thing on everybody's mind. So taking a look back at Justice Kennedy, as we said, he sides with his liberal colleagues on social issues typically. He reaffirmed the Roe v. Wade decision, which I'm sure you've seen a lot of in the news lately, as Democrats are concerned that the Roe v. Wade decision is going to be overturned, despite being precedent since the 70s, if a fifth justice that is strongly conservative is appointed to the bench. But Kennedy, who was this swing vote, as we said, managed to vote to affirm or reaffirm Roe v. Wade. In the famous same-sex marriage case, making same-sex marriage lawful back in 2015, he was the deciding vote there as well, voting in favor of same-sex marriage, saying that it is protected under the Constitution. And recently, if anybody attended any of the recent seminars, any employment law seminar where I'm sure you heard about this class action waiver discussion, he actually voted for the employers. Again, it's not so much a social issue. He voted in an employment law issue with his conservative colleagues, finding that class action waivers and employment agreements do not violate the National Labor Relations Act. So he has upheld conservative values there. With the retirement, his swing vote importance will not be understated by any stretch, because it will quickly be noted how important such a vote is. So why does this matter for what we do every day when we come into work? So Title VII, something we all deal with depending on our size, but we all largely deal with Title VII. There's a current circuit court split on whether or not sexual orientation is covered under Title VII as part of sex discrimination on the basis of sex. We all know New York State, sexual orientation is considered a protected category, but we're not there yet on the federal level. It's come up many times in the past. The Supreme Court has rather consistently said it is not covered. Sexual orientation discrimination is not protected under Title VII. But there's a thought that could be changing with changing tides. The Second Circuit, which is all of New York, and the Seventh Circuit, which is in the Midwest, have issued opinions suggesting that it is impossible to discriminate on the basis of sexual orientation without discriminating on the basis of sex. So what that means is it's very hard to differentiate between sexual orientation and sex. If someone is being discriminated against because he or she is gay or perceived to be gay, then arguably the theory goes is, well, isn't that because that's based on their sex? It's because it could be a male who likes men or a female who likes women. So isn't that because of my sex, which then in turn ties to sexual orientation? That's the Second and Seventh Circuit's opinion that yes, it is covered. It is they are essentially one and the same. Other circuits have not reached a similar determination, but anytime we reach a circuit split, that's often an issue that is ripe for the Supreme Court to take on. If we saw it Now there's a chance that Justice Kennedy would have been the swing vote to say it is protected under Title VII, and it could have been a 5-4 decision with Sotomayor and Ginsburg and Kagan and Breyer, with then Kennedy saying, yes, it's protected, and changing the landscape of Title VII. However, with Kennedy stepping down and his replacement soon to be named, if that replacement is confirmed and a strong Republican or a Republican mindset, as we all believe it would be, according to what President Trump has stated, then largely this is likely going to, the law is going to remain. Title VII will likely be construed narrowly. It will not be construed to include more. It will stick the way it is. But again, this is for at least people of the Democratic mindset or of the mindset to expand Title VII to cover sexual orientation. Justice Kennedy's retirement is somewhat of a blow to that thought process. So for the future, President Trump, you'll hear probably this week in these coming months about this list of names that he has, the Supreme Court nominees. The list has been vetted. They're all, some of them are Congress people, some of them are judges, federal, state court judges. They are all strongly conservative. They would fit the role of the Republican side of the bench, which is what we all expect. President Trump has been on the record in the past as saying that he wants to appoint justices that will overturn Roe v. Wade. And with, as we said earlier, with the Republicans holding the Senate majority, they are in a key position to be able to, let's just say, push through the nomination or the confirmation of whoever President Trump appoints to the bench. Come November, when they could lose that majority, if it's not decided, then we could be having an entirely different discussion. We could be seeing the battle that we saw over Merrick Garland, who, if you remember, was President Obama's nominee that never got a confirmation hearing because the Senate Republicans said they were not going to give it to a lame duck president, which President Obama was in the final year of his second term. And we already went over the last bullet point, but if this goes this way, pro-employer decisions are largely expected. So we talked earlier, I'll shift off of Justice Kennedy onto this labor law decision. This Janus versus AFSCME Council 31. This was one of the final decisions to come out on Wednesday, the end of the term. As I said, it was Justice Kennedy's final decision. And what did it hold? So stick with me, and I'm going to explain to you why everybody on this call should listen, even though you're not a public sector or you might not be unionized. This is why you listen. But first, what did it hold? The court held public sector workers who are not union members cannot be forced to pay agency fees, or we could also call them fair share fees, where the employee pays his or her fair share, that cover the cost of collective bargaining. The court voted 5-4, overturning 40 years of precedent, which said that non-union members who are still in the union, but they're not a member, they are still in a unionized workplace, have to pay these fees for collective bargaining purposes. That was required under law since, I believe it was 1977, in a case that we're going to get into called Abood. But now we're saying the court is now saying they are not constitutional. You cannot, it's a violation of the First Amendment. You cannot force somebody to pay these fees in the public sector. So as we are saying, this is one of the slides that I think everybody on this call is going to want to listen to. On its face, you may think this Janus decision does not impact your workplace. I'm here to tell you to think again. With the union's ability to collect these fair share fees in the public sector now kind of stalled, they can't get them based on this decision, unions are going to have to look elsewhere for money. So where are they going to look? They're going to look inside your doors and everyone else's doors. They want to go to the private sector. They got to find a way to recoup their money now that they just were told that they're going to lose it. So while we're operating on this federal level and in the public sector, keep in mind, New York remains the most union-heavy state in the country. Last year, according to the U.S. Bureau of Labor Statistics, 23.8% of New York employees were union members. That's a total of over 2 million employees. There is enough here for unions to try to get in to the workplaces of people on this call when they normally in the past would have not even batted an eye at you. So their mindset of the unions is, white collar, is millennials. They want to get into the new workforce because, hey, it's dues money, and they think they can offer what the new, young, growing workforce wants. Millennials want, according to studies, millennials want better benefits. They want health coverage, health benefits. They want job security. So under a collective bargaining agreement, it is not as easy to separate employment because you typically have to have just cause for termination. Harder to prove. You have to go through a union usually to terminate one of your employees if they're covered by the union. So what we expect to see, and why everybody on this call needs to be vigilant, is we expect to see unions becoming much more aggressive in their attempts to organize all workplaces, especially private sector. They will sell a bill of goods to try to get in the door, and if they do, then it becomes your issue that you have to deal with. So just for those who care or are interested, a little bit of background on this Janus case. So he was an employee, or he is an employee, was an employee of the Illinois Department of Healthcare and Family Services, and he's represented by a union, but he's not a member of the union. It's an intricate distinction. As a non-member, the collective bargaining agreement between Illinois, the state of Illinois, because it was the Illinois Department of Healthcare, a state agency, and his union required him and other non-union members to pay a fair, or a non-member of the union, I should say, to pay a fair share fee. This would cover the cost of collective bargaining and contract administration. What it doesn't cover is political actions or ideological actions of the union. So if they contribute to a candidate in politics, it won't cover that, but it covers basically getting the terms and conditions of employment, the collective bargaining process. He refused to join the union. Janus did because he opposed many of their policy positions. So previously, and I alluded to this a little bit earlier, prior to this Janus case, these fair share fees where people like Janus would have to pay just because they get the benefits of being, having a union in their workplace, these fees were constitutional since 1977. So again, they could not be forced to pay for, the non-members cannot be forced to pay for political or ideological activities. Seventh Circuit it upheld Abood, this 1977 case, said the fees are constitutional, so it kept the law the way it is. Janus petitioned the Supreme Court. A similar case in 2016 was heard, and this was during the whole Merrick Garland, President Obama attempted appointment and confirmation. A similar case from a California school teacher came up in 2016, and the court split 4-4 along party lines. And the reason why they split is because Justice Scalia had passed away, so there was nobody to, sway the conservative vote 5-4. Otherwise, could have happened, but didn't. So we wait. So Justice Alito, one of the President Bush appointees, wrote the decision. This was done on party lines, with Justice Kennedy voting with his conservative colleagues. Moving forward, unions that represent public sector employees anticipate that a significant number of non-members will cease paying agency fees, because why are you going to pay something you don't have to pay anymore? So they're going to stop doing, they're still going to get the benefits of the contract. So it makes good sense for them to not pay. Any of you that deal with the SEIU, one of the largest unions in the country, especially here in Long Island, they laid off a bunch of employees in anticipation of this decision. As we said earlier, this is going to have an impact on the private sector. However, we have not seen it yet, but you will. So going forward, what might we see from unions? They are likely going to try to attack the private sector, as we said. They need to find a way to make up the money that they're not going to have anymore from these fair share fees. They are going to step up their organizing efforts. They are going to try to represent more employees. So you need to be alert, be cautious of, keep your ear to the ground, listen for, this type of talk, and then, confer with your attorney regarding what, if anything, you could or should do. Unions are going to have less money now, so it's going to be, currently there's going to be possibly more selective in what they take to arbitration, which is a good thing for employers. It saves money, and they will likely seek to find other pro-workers or pro-employee rights groups or entities or individuals to help them in getting into the workplace so they can build up their funds again. So with that, we are going to wrap up right here. I thank you, everybody, for joining and attending and listening to me talk about these exciting Supreme Court developments. Have a great weekend and happy 4th of July, everyone.